Following the Court of Appeals, the highest state court in New York, more than a few courts have adopted this dubious view of marriage, an institution which, as several scholars have shown, is not about encouraging responsible procreation, indeed is not about procreation at all, or at least hasn't been in recent times. If that were so, right, if marriage were just about procreation, if those things were so inextricably linked, then presumably the infertile couldn't marry, or the state could dissolve childless marriages after, say, 5 years or so of that marriage. If marriage were about procreation, then presumably a spouse could get an annulment if the other spouse was infertile, something which isn't the case under law in any jurisdiction that I know today. So, where are we with marriage equality in the United States? Let's start in New England. Here, with the exception of Rhode Island, which is, I assume, sort of why we're all here, right? Marriage equality for same-sex couples is universally recognized, or at least will be in January 2010 in New Hampshire. In 2 New England states, Massachusetts and Connecticut, marriage equality was mandated by the judiciary, whereas in 3, Vermont, New Hampshire, and Maine, marriage equality was legislatively achieved. Of course, it remains to be seen what will happen here in Rhode Island. What's interesting about New England, I think, is that marriage equality progress has occurred in the political arena no less than it has in the judicial arena, something about which I will have a few more words to say in a moment. On a national level, and this is just to give you a kind of rough sense of where we are nationally with respect to the issue of marriage equality. On a national level, the states fall into roughly 4 categories with respect to marriage recognition, or their lack thereof, for same-sex couples. So first, there is affirmative non-recognition, right? That is those states or those jurisdictions that actively prohibit same-sex marriage or marriage equality for same-sex couples in the form of a state law, like a state mini-DOMA, Defense of Marriage Act, or state constitutional amendments, which is most states. 2, passive non-recognition, that is those states like Rhode Island that lack a law or constitutional amendment banning same-sex marriage, explicitly banning it, but which also do not affirmatively recognize it. 3, affirmative recognition, that is those states that recognize same-sex marriage, the ones I just discussed. And 4, recognition of a parallel scheme, that is those states like California and New Jersey that recognize a parallel legal status for same-sex couples, like domestic partnership or civil union, but just not marriage. This latter category is growing in the United States, as Nevada and Wisconsin recently passed domestic partnership laws for same-sex couples who desire to have some legal status by their state. Here, the legal issue is whether or not nominal equality is constitutionally required. That is, whether it is constitutionally permissible to establish a legal relationship for same-sex couples that is substantively identical to marriage, but nominally different. Right? These cases are actually very interesting because the issues, this really is the issue in Prop 8, and with Prop 8 in California, right? The issue is it constitutionally required to extend the same name to legally recognized same-sex couples? So I'd like to close here with just a few words, sort of what I was saying earlier about our tendency, I think, to have a court-centered or jurist-centric approach to the issue of marriage equality. By which I mean the tendency to rely almost exclusively on courts in constitutional arguments to achieve equal rights for same-sex couples who desire to enter into something that's called a marriage. In a recent New Yorker article written by legal analyst Jeffrey Toobin on whether, quote, Obama's judges are really liberal, end quote, Toobin writes that, quote, Obama's choice of judges reflects ferment in the world of legal liberalism, which is tied ever more closely to the fate of Democrats in the executive and legislative branches of government. Liberals who once saw judges as the lone protectors of constitutional rights are now placing their hopes on elected politicians like Obama, end quote. On the issue of same-sex marriage in particular, Toobin quotes Yale law professor Jack Balkin, who maintains that, quote, same-sex marriage right now is a collaboration, where courts are leading, like in Massachusetts, and sometimes in other states, the courts are taking up the question and forcing the attention of the polity on it. But courts can only push so far out against what the people believe. They can lead, but they have to get some degree of take-up from the legislature, or nothing is going to change, end quote. In other words, both legal and political forces work, or should work, hand in hand in shaping legal constitutional arguments for marriage equality for same-sex couples. I think we tend to place so much power, especially lawyers and law students, so much power and so much faith in courts to resolve constitutional issues like same-sex marriage, and we tend to think about the quote-unquote legal case for marriage equality almost exclusively in terms of how courts either will decide or have decided that constitutional issue. That we forget, we place so much faith and so much power in the courts, right, that we forget about the power of the legislature, right, of the people to do the same. This is all just a very long way for me to conclude my remarks on the history of marriage equality in the United States and New England and Rhode Island by pointing out that the legal case for same-sex marriage throughout the states, right, but particularly in Rhode Island, might very well be, since that's an issue that is still pending, might very well be politics and political activism, a trend rather than just placing so much power in the courts to resolve that issue. A trend which has surely started in New England, given that 3 states here have legalized same-sex marriage legislatively rather than through judicial mandate. So it's a trend that has surely started here in New England, which Rhode Island, many hope, myself included, could very well continue. Thank you.
Good evening. First of all, thank you, Megan. Thank you for the Alliance and Rhode Island Wing Democrats and Democrats, right? That was it. I wanted to get more.
Oh, yeah?
I'm not alone. Actually, my name is Frank Ferri, and I am a state rep. I'm in my 2nd year. And I wasn't a law student. I wasn't a politician. I was fine in my neighborhood. Actually, me and my husband, who were married in Vancouver, we have a great relationship with our neighborhood. And I know we're here to talk about what the status is at the State House right now as far as the bill goes. But I think what I wanted just to say before that is that I think the state of what people think about marriage equality and same-sex marriage has been changing over all these years now. That as long as when somebody finds out that they have gay neighbors or that they're married and that their relationships are just the same as everybody else, support grows. That we're not a danger to anybody's marriage. As a matter of fact, if you come to my neighborhood, you're part of everybody else's life and family life. But with me tonight is Art Handy, and our bill was first introduced in 1997 by Rep. Mike Pizzatora. So there is a history of the marriage bill in Rhode Island. It probably was the first marriage bill introduced in New England. So here we are, the first and the last. So, and support has grown over the years. But I'm going to refer that to Art, because Art has been the sponsor of the bill for the last 8 years, six or 7 years. And I mean, we can let him start from when he sponsored it, and then maybe come up to date so we all know.
Sure, and I think you booked 15 minutes for us, but I don't think it's going to take up, I'm going to save that time for the Q&A at the end. I think it'll work better for us. It's just one piece of legislation, no matter what. And I also really enjoyed the legal analysis there. I'm not a lawyer either. I'm Art Handy. I'm a state representative in Cranston. I'm in my 7th year in the Assembly, and we just we're about to finish up, I guess. And I've introduced the bill 7 times, all 7 years.